I did not know how to operate this phone. I just got my mic on. I'm sorry.
Okay. LaDuana Brown, good morning.
Good morning.
Do you have an attorney, Ms. Brown?
No, no, I don't.
Do you want an attorney?
No, sir.
Okay. Well,
I'm sorry. No, Your Honor. I'm sorry. No, Your Honor.
It's okay, sir. It's appropriate. Okay, Attorney Coleman is on your matter. That's the plaintiff's attorney. So you'll want to talk to him when he gets some free time. He looks like he's in and out of the breakout room. So I'll notify him that you're here. You're also named now, so you can be identified.
I don't know how to do it. I'm gonna try. I don't know how to operate this. I'm sorry.
No, I'll rename. We renamed you. So I just need you to put your hand up in the chat. It's a button. I think it says like more features, something on the bottom of.
Okay, I was trying to do that also, but I didn't. Okay, so just hit raise hand.
And keep that up so then Attorney Coleman can see.
Okay, thank you.
You're welcome. Thank you.
Mm-hmm.
Samuel Wright. Are you ready on Samuel Wright, Attorney Coleman?
Yes, we're ready to go on the record.
All right. Calling case number 2239-7425. This is Orleans PO LLC versus Samuel Wright and occupants on Larned. May I have appearances?
Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Thank you. Samuel Wright, can you state your name for the record?
Samuel Wright.
Thank you, Mr. Wright. Our parties worked out in a resolution.
Yeah, we've entered into a conditional dismissal whereby we've agreed that there's a total of $3,579 owed in rent, $159 in court costs, for a total of $3,738. And Mr. Wright has agreed to pay those amounts by March 31st, 2023. I explained to him that I would be checking for B, and that would mean that if he didn't make that payment, that a writ could automatically issue. And Mr. Wright, is that our agreement?
Yes, ma'am.
And do I have permission to sign your name to this agreement?
Yes, ma'am.
All right, the court entered a conditional dismissal. Good luck, Mr. Wright.
Thank you.
Have a great day.
You too.
Thanks, Jason.
Thank you. Yes, I kind of like to stop the action. And now, the ace on the first rule of war there is to know your enemy. Always strength and frequency. Don't be concerned. I'm rugged in the spirit. And look, good. Because I know that I'm capable of it, but the last president, another kind of guilty done the war. Mr. Baker?
Mr. Andrew Neighbor.
Baber.
I had it right the first time. Good morning.
No, it's Baber, B-A-B-E-R.
Oh, Baber.
Yes, Your Honor.
Okay, I have you down as it's Andrew Barber on here on the docket. So I'll check you in. And Attorney Coleman, do you want to speak to legal counsel?
Yes, I don't have any, but I'd like one.
All right, Lakeshore Legal Aid is here. I'm going to invite you to a breakout room. This is Lakeshore in a breakout room. I'm gonna invite you to room 4. We receive a prompt, Mr. Mr. Baber, can you join that breakout room?
Okay.
All right. Attorney Coleman, you have anything ready?
Yes, Your Honor. We have the case ending in 878 with myself and attorney to be Hogan.
Okay. On case number 22397878, Golden Key Real Estate versus Demisha Latham and all occupants.
Your Honor, for the record, attorney Frederick J. Coleman, P 56548, on behalf of the plaintiff. This is a subsequent hearing on a non-payment of rent.
Camry Hogan's requesting to practice under the Michigan Court Rule 8.2120 under the supervision of Marie Rumors, P number 82841, on behalf of the defendant, Ms. Demisha Latham.
Your Honor, we've had an
Good morning.
opportunity. Good morning, Judge. We've had an opportunity to discuss this matter. Sister counsel is asking for a brief adjournment. I have no problem with that, so she can look into some issues regarding Sarah payments and things of that nature. So we're asking for about a 2-week date if you have that available, or whatever you have close to that time frame.
What days are best for you, Ms. Hogan? Are you in school right now?
Nope. Our docket days for JOC are Tuesdays and Fridays, so those are good days for me.
Okay.
I'm sorry, I have class on Tuesdays.
You said, let's try to do a Friday. Let's see. Get March. It's March 31st. Anything on March 31st? Is March 31st enough time?
Yep, that's great.
Ow. Ow.
Only 4 for March 31st.
Okay. Let's do March 31st at 9:01.
9:01.
We'll put 9 o'clock. I just know it's an adjournment that way.
And Your Honor, I wasn't even gonna say anything this time, see?
Yeah. Eventually, you'll grow to appreciate it. All right,
Yeah,
I'll see you all back on the 31st at 9:01 a.m.
Thank you, Judge.
All right, you're welcome. Have a great weekend.
You too.
Thank you.
Your Honor, question, Miss Harris, is someone representing you, Miss Harris?
They said they can't speak for me.
All right, me and you can go into the breakout then room. Can you meet me in room number? Let's see here.
It's crowded today in the breakout room.
Room number 8. Can you send
Okay.
room number 8, Judge?
Room 8,
Yeah,
and who is this? Brianna Harris?
that's Brianna Harris.
Okay. Okay.
You'll get an invite, Miss Harris. I'll meet you there.
Thank you.
Is anyone ready on any matter? Are any matters ready? Kaisha Clark here.
Yes.
Okay. Good morning. Are you represented by counsel?
No.
Do you want to speak to counsel?
Yes.
That was Ms. Clark. Are you on as, can you speak again, Ms. Clark?
Yes.
How do you pronounce your first name?
Keisha.
Keisha? Okay. Can you put your hand up in the chat? I'll invite you. Put you 10. Scout. Is Anthony Battle here? Is LaShawn Berry here? Is James Johnson here? An iPhone with the checkered shirt. Can you remind me of your name?
Yes, LaDuana Brown, for under
Okay.
voting.
Golden LaDuana Brown.
Yeah.
Did you log out and come back in?
My phone rang. I told you, Your Honor, I'm unfamiliar with this, and I tried to dismiss the call, and I had to go out, come back in.
Okay, I was just, 'cause I thought we named you once, but I think
Yeah, it was me. It was me.
it's all right. It's all right. Good morning, Ms. Hargrove.
Good morning, Judge.
What time is your case scheduled?
It was for 9:36, sir. I've been here waiting for a minute.
What's your case number?
Case number 2239-7117.
Okay. Diane Wyrock's case. Attorney Rock. And your name is Sharonda Hargrove.
Yes, sir.
Do you have legal counsel?
No, sir, I don't.
Do you want to speak to legal counsel?
Yes, sir, please.
All right. Can you put your hand up in the chat?
Okay.
Very fast.
Your Honor, I have another one ready.
Okay. Ms. Hargrove, let's see. There's someone from Lakeshore Legal that can talk to you. Keep your hand up. All right, Attorney Coleman, which one do you have? What do you have ready? Attorney Coleman?
I'm sorry, Judge, I thought I was on mute. The one ending in 870. This old
870.
age is something special, isn't it?
I agree. I try to. Now, calling case number 22397870, Rhapsody LLC versus Brianna Harris and all occupants.
Good morning again, Your Honor. For the record, Attorney Frederick J. Coleman, P. 56548, on behalf of the plaintiff. Ms. Harris, identify yourself, please.
My name is Brianna Harris.
Good morning, Ms. Brianna Harris.
Your Honor, myself and Ms. Harris had an opportunity to discuss this matter in the breakout room. She previously had an opportunity to speak to counsel. They were unable to represent her, to my understanding. What the parties have agreed to today is that case should be dismissed as to Brianna Harris. All occupants must either pay or vacate by April 17th, 23, or writ to issue. Also, landlord shall inspect and repair habitable issues. The amount owed at this time is $4,800. There's court costs and statutory attorney fees of $157 for a total amount of $4,957. MCR 4.201 subsection I was explained to the defendant, basically that she has 3 business days from today's date to file a motion asking the court to reconsider this matter, as she's not represented by counsel, and I am counsel. Also, she has 10 days to appeal to a court of higher jurisdiction, that being the Wayne County Circuit Court, if she wants to challenge this at that level. That is the agreement of the parties, Your Honor.
Harris, do you understand the agreement?
Yes.
All right, the court will enter this judgment by hearing.
Correct, Your Honor.
We do a judgment by hearing. You submitted though, counsel?
Pardon? Yeah, I'm submitted.
Okay, all right.
It'll be coming to you either by the end of the day or first thing Monday morning. The plan is by the end of the day.
Okay.
Okay, anybody got anything else ready for me? I'm ready to roll.
Am I free to go?
You are free to go, Ms. Harris. Have a great weekend.
Thank you.
Is James Johnson here? Is Anthony Battle here? Is LaShawn Berry here? Is Nancy Knutski here? Is Thomasina Robinson here? Good morning, Mr. Norsegian.
Good morning, Your Honor.
All right. Are all of your matters adjourned except for one?
Yeah, that's the way I have it on my schedule. I have 4 that were adjourned and excuse me, 1 that's a regular hearing.
Doing default hour after scheduled time, but I can call your 10s and 10:01s. It's 4. So start there. Is anyone here from 3806 Grand Street in the city of Detroit?
Yes, Your Honor.
All right, and what's your name?
Michael Curtis.
Good morning, Mr. Curtis. Are you represented by counsel?
No, sir.
Do you want to speak to counsel?
Yes, sir.
Please put your hand up in the chat. Legal aid, can you?
How
Ms.
do I
Brown?
do that?
Okay. Ms. Brown, are you waiting to speak to legal counsel?
How do I do that?
No, no, I'm waiting to speak to Attorney Coleman.
Okay.
Yeah, we can go into a breakout room.
Okay, Mr. Curtis, 1 second.
I don't know how to put my hand up, Your Honor.
It's at the bottom under like more gestures, I think.
Okay, let me see. I got it right here. Thank you.
Well, so I'll put you all, Attorney Coleman, I'll put you in room 9 with Ms. Brown. Ms. Brown, you get invited to a breakout room 9.
Okay, thank you.
All right, Mr. Curtis, let's see if we can find Lakeshore Legal. I don't see anyone is there anyone in the lobby? Let's see if anybody is. Mr. Keenan,
Yes, Judge.
Mr. Curtis would like to speak to legal counsel.
All right, Mr. Curtis, in just a second, you'll see a prompt on your screen for a breakout room. And then Ladwana Brown, I also see a hand up. Do they need to speak to counsel?
No, she actually just wanted to speak to Attorney Coleman.
Okay. All right, Mr. Curtis, just 1 second. We'll find you an attorney.
No problem.
That's case number 141. You reside at 3806, correct?
Yes.
Okay. All right. Terry McFarland here? Or Eddie Turner?
Yes. Terry McFarland is here.
Terry McFarland is here. All right, Mr. Narcigi, that's not one of your cases, but it's in between your cases. Good morning, Ms. McFarland.
Good morning.
Does anyone reside at 15335 Wildemere? One 5335 Wildemere.
This was, Your Honor, this was the gentleman who filed a lot of interesting paperwork on this case. So I have a feeling he's going to show up at some point.
Okay, I'm in receipt of defendant's motion to dismiss. All right. Let's wait for him to show up. And does anyone reside at 4706 Somerset? Anyone on Somerset? Does anyone reside at 8424 Plainview? Eight four two four Plainview. Does anyone reside at 1514 West Philadelphia? Are there any occupants of 15881 LaSalle Boulevard? Are there any occupants at 15881 LaSalle Boulevard? Person unmuted, what's your name? And West?
Yes, Your Honor. Can you hear me now?
Yes. Do you reside at 15335 Wildermere?
I do.
All right, and could you tell me your full name?
James West.
James. Thank you, Mr. West. Good morning. Have you checked in? I see you. I'm in receipt, Mr. West, of a motion to dismiss. So I'll hear this. I have your pleadings. So we'll address this today. Okay. And your petition, temporary injunction. Mr. Narsigian, did you receive a copy of?
Yeah, I received a couple different mailings from Mr. West.
All right, let's there's something. There's an answer. So you have an answer in affirmative defenses.
Yes.
And we're off the record. I haven't called this case. And then there's a motion to dismiss and also a petition for temporary injunction. And everything is essentially numbered to 1 to 14.
Yes, I believe I have all those documents.
So it's nothing beyond 14 pages, correct?
I don't think so, Your Honor, no.
All right, Mr. Narsigian, did you get 14 pages?
I'm sorry, say it again, Judge.
Do you have 14 pages from defendant?
Yes, I do.
Okay, all right. All right, well, I'll call this matter probably after 11. I'll try to get these other matters, whatever's ready, And if nothing's ready, then I'll just call.
Okay, Your Honor. And you said you were gonna wait how long before you did defaults? Because I'm gonna jump back to Judge Sherman's courtroom if that's not a problem.
That's not a problem. An hour. So if
Okay.
you come back at 11, we can do your
Okay.
default, address whoever's here, who spoke to counsel, and then we'll wrap it up with this matter.
Perfect. Thank you.
You're welcome.
How long are we waiting for defaults?
An hour,
Okay, thanks so much.
no problem. Is Genevieve Douglas here?
Yes, Your Honor, I'm here.
Okay. Good morning.
Good morning.
Jason Johnson. I think you're still muted, Attorney Coleman. Are you ready on Brown?
I'm ready on Brown.
Hello.
Calling case number 2239-7876. This is Golden Key Real Estate versus LaDuana Brown and occupants on Ashton. May I have appearances for the record?
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548, on behalf of the plaintiff.
Thank you.
Ms. Brown, identify yourself, please.
Yes, I'm here.
State your name for the record, ma'am.
Oh, I'm sorry. LaDuana Brown.
Your Honor, myself and Ms. Brown have had an opportunity in a breakout room to discuss this matter. This matter before the court is a non-payment of rent. We'll be doing a judgment by hearing. The case should be dismissed as to LaDuana Brown. All occupants must either pay or vacate by May 1st, 23, or enter into a written payment agreement. MCR 4.201 subsection I was explained. The amount owed is $4,500. Court costs and statutory attorney fees of $157 for a total amount of $4,657.
Is that your understanding of the agreement, Ms. Brown?
Yes, Your Honor. Yes, Your Honor.
All right, Ms. Brown, you are to pay $4,657 or vacate by May 1st, 2023. And there will be a dismissal to your name and a judgment entered for all occupants. Good luck, Mrs. Brown. Have a great weekend.
Ms. Brown, it was a pleasure talking to you. Wishing you the best, praying for you. Talk to you soon.
Yes, see you on the flip side. Thank you.
Okay, take care.
Bye-bye.
Your Honor, do I have anybody else would love to speak to me? I'm in a speaking mood.
Yeah.
Has anyone spoke to Ms. Clark yet? Ms. Clark,
Yes.
has anyone spoke to you yet?
I just spoke to the attorney.
Are they able to represent you?
No.
Then, Your Honor, if you can put me and Ms. Clark into a breakout room so we can discuss this matter. Ms. Brown, you are free to go. That will be mailed out to you.
I'm sorry, you guys. I don't even know how to get out of here.
All right, Ms. Clark, just, when you see a prompt, when you see a prompt, click join. I'm going to invite you to room 11.
Ms. Brown,
Okay.
Ms. Brown, if you go back and look at what you did to come into the court, come back, leave, there you go, push leave and you just leave the courtroom. I'll be right back, Judge.
And Ms. Story, have you had a communication with counsel?
Yes, I did, Judge. Thank you so much and good morning. I wanted to speak to Mr. Coleman when he was finished, sir.
Okay, good morning.
Awesome. Thank you so much, Judge. And I voted for you. Congratulations.
Thank you.
You're welcome.
Thank you for participating in the election.
Your Honor, Ms. Clark didn't make it.
Go ahead. Go ahead, counsel.
I said Ms. Clark did not make it into the breakout room. She's still in here.
Ms. Clark.
Yeah, nothing ever popped up.
All right, we're gonna move you to room 12. 'Cause I don't really know how to. Did anything pop up, Ms. Clark?
Okay, there it is. Thank you.
Welcome. Ms. Story, Attorney Coleman, you see what he's doing. So once he's done talking to Ms. Clark, talk to you. Good morning, Ms. Badon.
Good morning, Your Honor.
What case number are you on?
This case. Who are you talking to, sir?
It is 223-97470.
Okay. With Robin Baum?
Badon.
Bayon, yes.
Yes.
Okay, did you speak to, Ms. Janet, are you represented by counsel?
Yes, sir.
Okay, who's your attorney?
Hannah Smith.
I was trying to get on Zoom, but.
Okay.
She had said the other day she had another case. I don't know if she's still wherever she.
She'll be around, and your case isn't until 10:30.
Okay.
31, so we have some time.
10:30. All right, thank you.
You're welcome.
My meeting ID number is 360436.
What's your case number?
360-436-0000.
Okay, what's your name?
Rosa.
Is that your full name?
Rosa Griffith.
Rosa Griffith. And what do you have a case? Do you have a case number as well?
Sir, the case number right here is 22397149. And I had no clue why you are, sending letters to my residents or anything of this nature. I don't know who these people are.
2239-7149.
22397149. And then there's an LT somewhere right there.
Yeah, okay. And are you represented by counsel?
You know what? I only got this letter Friday to show up here. The other two that came prior to that came on the same day and the day before. I have no clue what this is about. So this is a pre-trial conference, it said, and I'd like to know what this is about.
For a landlord-tenant hearing.
Sir, there is no landlord-tenant here.
Do you own your house?
Yes, sir.
All right, and
I do have some shady neighbors, you know, 2 doors down, and they've been definitely given, you know, free, they get free whatever they're getting over there. But I'm sure they're trying to make confusion, but nope, this is Rosa Griffith. I tried to get Zoom. I can't figure that out. And then it said all occupants. I mean, who? You should at least tell me my name. You're going to send me letters to have you come to court. That's crazy. It said everybody in the house. How you going to do that? I got kids at first. I got it in 5th grade, 7th grade. What do you want me to do? The whole house full. They won't even tell me what it. Speak,
are you
sir.
at 1472 Vinewood?
1472. Yes, sir. Detroit, Michigan, 48216.
And what's your name again?
Rosa Griffith. There's maybe a hyphen, you know, Casares Griffith, but nope, my license says Rosa Griffith. My bills say Rosa Griffith. I'm Rosa Griffith.
You're Rosa Griffith.
Born and raised here in Detroit, Michigan.
Well, happy Friday, Miss Rosa Griffith.
Pardon me, sir?
So happy Friday. Good morning.
Oh, yeah, happy Friday. Right, my boss loved it. I got a day off today. He hated it.
All right, I'm looking at your matter. This is a complaint to recover possession of property. I'll call this when Mr. Narsigian is back in the courtroom, and maybe we can come to a resolution on this matter.
Sir, I'm sure that I'm going to get more mail and be more clear about what's going on here. And, you know, I've been living here with my family, my whole world. I don't do no, you know, mortgages or none of that nature. And I don't know who this person is, but here in Detroit, born and raised here in Detroit, this is shady business. I don't know what this is. I need more clarity here.
All right, well, I'll call your case shortly, ma'am. Just sit tight. We have about 30 cases. So I'll process some people didn't appear, we'll process them and then we'll get to you, okay?
All right, so I just stay on hold, right?
Yes, ma'am.
Okay, then here I sit. I'm over here at 36th District Court.
You're here?
Yes. Because I got 3 letters in 1 week, and the last one was just a few days ago. And if I wouldn't have read it, I wouldn't have known. All of them are different courthouses, different judges. I mean, they're all different. One says don't appear. It says, and this last one says make sure you're here. So I'm here.
All right. Well, where are you? Come to the courtroom.
I'm on the I don't even know exactly what floor this is, where you get information. I'm on the 2nd floor.
We'll come to 436.
36?
436.
Come to court. 436? Okay, thank you. I'll be right there.
If they stop you, just tell me I have a hearing here.
Okay, I'm gonna come right upstairs right now. Thank you.
Take your time. Take your time.
I'm gonna hold on now.
All right.
I'm gonna hold on.
I'm gonna mute you, okay? Is anyone, any cases, are any cases ready?
Your Honor, this is Coleman again, 877.
Eight, seven, seven. On case number 22397877. This is Golden Key Real Estate LLC versus Keisha Clark, and occupational scope. May I have appearances?
Your Honor, again, for the record, Attorney Frederick J. Coleman, P. 56548. On behalf of the plaintiff, had an opportunity to speak to Mrs. Clark. Ms. Clark, please identify yourself for the record.
Yes, I'm here.
State your name for the record, ma'am.
Keisha Clark.
Your Honor, myself and Ms. Clark had an opportunity to discuss this matter. We'll be entering a judgment by hearing. The case should be dismissed as to Ms. Clark. All occupants may either pay or vacate on or before May 1st, 2023. The amount owed is $5,161.50. MCR 4.201 subsection I was explained. It was explained to Ms. Clark that since she's not represented by an attorney, and that since I am an attorney, this matter does not become final for 3 business days, in which she has a right to file a motion asking this court to reconsider this matter. Also, she has a right within 10 days to file an appeal with a court of higher jurisdiction, that being the Wayne County Circuit Court. That is the agreement of the parties, Your Honor.
All right, the court enters this judgment by hearing the redemption amount of $5,161.50 to be paid by May 1st, 2023.
That's correct, Judge.
All right, good luck, Ms. Clark. The court will enter this judgment.
Ms. Clark, you're fine with that? You understand everything, correct?
Yes.
All right. Well, thank you much. Praying for you. Hope things get better.
Thank you.
Wishing you the best.
All right.
Thank you, Ms. Clark. Have a great day. Our Ms. Story is here.
I'm still here, Judge. Thank you.
Attorney Coleman, she's not represented by counsel. She would like to talk to you. This is case number 875. And you're muted, but I'll invite you both to room number 11.
Thank you.
Well, story. Story, did you get a prompt?
It said I was moved to 11, but I'm still here with you.
I think you have to press OK.
All right. I'm ready.
Did you get a prompt now?
Nope, it just says move. I have been moved to room 12, but it gives me no prompt. Let me lower my hand and let me see if that's why. Okay.
See if you can click breakout rooms. Is there a
Okay.
breakout tab?
Yes, got it. Thank you.
You're welcome. Attorney Coleman. I think she's
Yes,
going back. She's back in room 12.
Okay.
Are you able to get back on? Okay. Good morning, Attorney Whiterock.
Your Honor, did you call my case?
I just said good morning. Sharonda Hargrove is here for case number ending in 117.
Yes.
She is present in the courtroom. I'm not sure if she's represented by counsel.
No, I'm not, sir.
Okay. Turn my rock.
And I'm stuck in 41A District Court. So
41A, what is that?
Sterling Heights.
It moved pretty fast over there.
Yeah, I'm waiting for the judge to take the bench.
You want to go in the breakout room, Ms. Hargrove, and then
Yes, that would be good.
when you're ready, if you all have to wait a minute, that's fine. But
Okay, thank you. Put me in the room.
You're Ms. Hargrove. Room 9.
Okay.
Where are you? Are parties ready to proceed on anything?
Are you taking default, Your Honor, for the 930s yet or not yet?
I believe you are eligible. Is Jamel Terry here? Is Abukar Muhammad present? Calling case number 2239-7439. This is Lafayette Park Place versus Jamel Terry, and occupants on East Larned. Apartment. Let me call this entire address out.
Okay, thank you.
1411 East Larned Street, Unit 103, Detroit, Michigan, 48207. May I have appearance?
Good morning, Your Honor. Cheryl Luckoff on behalf of the plaintiff, P45149.
Good morning. Is Mr. Terry here? Is Jamel Terry here? Mr. or Mrs. Terry? Mr. or Mrs. Terry? Does anyone reside at 1411 East Larned Street, Unit 103? Court has proof of service, as well as a summons complaint and demand for possession. Counsel, are you requesting a default judgment?
I am, Your Honor. Rent to retain possession here, $3,176. Court costs $159. The total amount due is $3,335.
3335.
Yes, possession only.
Okay, possession only. And are you seeking statutory move-out date?
I am, Your Honor. Which would be the 27th if the court is providing that date as a writ date.
March 27th.
Thank you.
2023. You are welcome. Defendant failed to appear. Calling case number 2239-7443, Lafayette Park Place versus Abukar Muhammad and occupants at 1449 East Larned Street, Unit 103 in Detroit, Michigan, 48207.
Good morning, Your Honor. Cheryl Luckoff on behalf of the plaintiff, P45149.
Good morning. Mr. Muhammad, Abukar Muhammad present. Is anyone at 1449 East Larned Street, Unit 103 present? Counsel.
Thank you, Your Honor. Plaintiff moves for entry of a default judgment of possession only. Rent to retain, $1,571. Costs $159. The total balance, $1,730 with a writ date of March 27th, 2023.
All right, you have service in the file. This is the second hearing. Are there any objections on either of these matters as a dismissal to named defendants?
No, there's no objection to that, Your Honor.
Okay. So I'll enter an all occupant judgment, default judgment for $1,730 with the pay or move date of March 27, 2020.
Thank you very much. Have a great weekend.
All right, you too.
Thanks.
And thank you, Ms. Hamlin, for being present.
Judge, the defendant on White Rock's case is not going into the breakout room. Ms. Hargrove.
Okay. All right, looks like Ms. Hargrove needs some help in room 9. Who's in room 9? Danielle Rollins. Which matter are you on?
For Midtown Park Apartments.
Good morning.
Good morning, how are you?
I'm doing well this Friday morning. I don't see you on my docket. That's why I'm curious. Midtown. What's your case number?
Sorry. I know it ends in 099. Give me that.
Okay, and Attorney Cohen, you're in JK scheduled for 10:30. So this is what I need.
I was gonna say I was being represented by Attorney Leslie Lott. She's not here yet, but let me see.
All right, this is what I need you to do, Ms. Rollins.
Yes.
Because you're in JK's courtroom. So I need you. Do you see the Zoom code that got you in here? The 360-436-0000?
Say that. You said say that again.
This is a Zoom code that got you in here. It was 360.
Oh yeah, I've been here before, so it just kind of saved it to my Zoom already.
All right, well, write this down because you need to be in a different.
Oh, okay. Let me get a pen real quick. Okay. Okay.
It's 360. 538. 0000.
Okay.
And I'm going to remove you from here and then just enter that code.
Okay. Thank you.
Well,
Judge Sabree, we have an agreement on the Hargrove case.
okay. I think you are you ready, Attorney Coleman? Excuse me.
Yeah, I don't want that title, not at this juncture of my life. I'm ready on this story. We have an issue with that one. If we can, you have the physical file in front of you? That's the case ending in.
All right, let's see. Keisha Story, Miss Story, ending in 875. I do. Ms. Wyrock, are you still trying to get back to 41B?
Yes, I am.
Are you,
And
you I'll call you right now and then, hold on one
Okay.
second.
See if she's stuck in the breakout room. She didn't know how to get out, I don't think.
Oh, she's still in the breakout room? Let's see. She comes out, I'll call it. I have the physical file, Attorney Coleman.
Okay, so Your Honor, what happened in this particular case is this. This case was filed twice. Once today, that case was dismissed, the ones before you today. That case was dismissed. There's another case in front of you that is scheduled next week on the 23rd. So Ms. Story will be coming back on, Ms. Story, you'll come back on the case on the 23rd. The case today is being dismissed. So that case for today is dismissed, Your Honor. Her next date in court is the 23rd.
Okay. On case number 22397875, Golden Key Real Estate LLC versus Kasha Story and occupants on Farmbrook. May I have appearances?
Your Honor, for the record, Attorney Frederick Coleman, P 56548, on behalf of the plaintiff. We're dismissed. This matter was dismissed as a duplicate. The other matter is still going to be before you, but it's not until the 23rd. So that gives Mrs. Story another few days to figure out, and we've already worked something out, and we will come back to that on that date. Unless you want to, well, we can't pull the file right now and do it. So we'll be back on the 23rd. Are you good with that, Ms. Story?
Oh, yes, sir. Yes, Judge.
He's the judge, he's the lawyer. It's on the 23rd at 10:15, and we'll be back then and we'll finalize this agreement, okay?
Yes, sir.
Have a great weekend.
Thank you, you too.
Yes, but it's a duplicate matter and we'll see that one when it's scheduled, when it's up.
Thank you.
That's Attorney Coleman.
Thank you, Judge.
All right.
Talking to you, Ms. Story. Have a blessed day. We'll talk next week.
You too. Everybody be safe, be blessed. Have a good one.
Thank you, Ms. Story. Have a good one. All right, Attorney Wyrock.
Yes.
Okay. Calling case number 22397117, Big Three Development versus Sharonda Hargrove and all occupants.
Good morning, Your Honor. Diane Wyrock on behalf of plaintiff P 59773, and we have an agreement.
Great. Can you please state the name for the record, Ms. Hargrove?
Sharonda Hargrove.
Thank you, Ms. Hargrove.
Your Honor, we have agreed to a hearing judgment against all occupants with a move-out date of 4/17/23. Is that correct, Ms. Hargrove?
Yes, ma'am.
So is this converted to a termination?
It is a termination.
It started as a termination and it will finish as a termination.
Yes.
Ms. Hargrove, are
Yes,
you
sir.
aware that this judgment by hearing is stating that you will vacate by April 17th, 2023, or a writ could issue on April 18th?
Yes, sir.
And your name is dismissed as a defendant and the judgment is entered for all occupants.
Yes, sir.
All right, thank you, Ms. Hargrove. Have a great weekend. Good luck.
Thank you. You as well, sir.
Thank you, Your Honor.
You're welcome. Have a great weekend, Ms. Wyrock.
Your Honor, can we do defaults for the Beal properties?
Yes, we can, counsel. Yes, we can. Is Anthony Battle here? Anthony Battle. Is LaShawn Berry here? LaShawn Berry. Does anyone live on Prairie Street? Anybody on Woodside? Is James Johnson here? Does anyone live at 5015 Maxwell? Oh, apartment buildings, huh? Does anyone reside at Nancy Knutski here? Does anyone reside at 9351 Woodside, apartment 4? Is Thomasina Robinson here? Does anyone reside on North Martindale Street? Calling case number 2239-7105, Bill Properties LLC versus Anthony Battle and occupants at 12003 Prairie Street.
Gabriel Lacy for Bill Properties, Your Honor, P 79685.
Thank you. No one has answered the call of the court. And appears defendant Anthony Battle is not present in court today. The date scheduled. Was this matter re-adjourned, counsel?
Yes, this is the third.
This is the third date, but
It was
set
adjourned
back.
on, yeah,
It was
on the
set
second
for-
date, it was adjourned
Okay, all right.
for a renotice.
For a renotice to ensure Mr. Battle's appearance or to provide better notice for Mr. Battle. The court is aware that notice was given. There's a copy on top of this file. There's proof of service in the file. Default judgment. Are you requesting a default judgment, counsel?
I am, Your Honor, possession only.
All right, is there a redemption amount?
Yes, the rent to retain possession is $5,050, cost of $160.75, total owing $5,210.75.
Default judgment is granted. Are you seeking a statutory default date?
Yes, Your Honor.
And that is March 27th. Is there an objection? Is there an objection to a judgment for all occupants?
I don't have, no, I don't have an objection to that.
The court enters this judgment as all occupants judgment. Calling case number 2239-7106, Bill Properties LLC versus LaShawn Berry and all occupants at 9351. So it's 9351 Woodside Street, apartment 2, Detroit, Michigan 48204.
Gabriel Lacy on behalf of Bill Properties, P 79685.
Thank you, counsel. Is LaShawn Berry here? Does anyone reside at 9351 Woodside Street, apartment 2, who's present in the courtroom? Counsel, are you seeking a default judgment?
I am, Your Honor. Rent to retain possession is $6,050, cost of $160.75, total owing $6,210.75.
All right, with a payer vacate date of March 27th, 2023. Any objection to dismissing named defendant?
No, Your Honor.
Court will enter this default judgment. Defendant failed to appear, and this case was scheduled for 9:36. It is 10:50. One second. On case number 2239-7108, Bill Properties versus James Johnson and occupants at 5015 Maxwell Street, apartment 2, Detroit, Michigan 48213. May I have appearances?
Gabriel Lacy on behalf of Bill Properties, Your Honor, P 79685.
Thank you. Is James Johnson here? Does anyone reside at 5015 Maxwell Street and apartment number 2? Counsel.
Rent to retain possession is $5,492, cost of $160.75. Total owing is $5,632.75.
Thank you. Default judgment is granted. We're gonna do a dismissal of named defendants and a judgment to all occupants with a pay or vacate date of March 27, 2023. Thank you, council. I think we have two more matters. Calling case number 2239-7109, Bill Properties LLC versus Nancy Knutski and occupants of 9351 Woodside Street, apartment 4 in the city of Detroit, 48204.
Gabriel Lacy on behalf of Bill Properties, P 79685.
Nancy Knutski here. Does anyone reside at 9351 Woodside Street, apartment 4 in the city of Detroit? And the court did not hear anyone respond to the call of the court. This case was scheduled for 9:36 a.m. It's now 10:52 a.m. Counsel, are you requesting a default judgment at this time?
I am, Your Honor. The rent to retain possession is $5,015, cost of $160.75. Total owed is $5,175.75.
Right. With the pay or vacate by March 27, 2023 date. Court will enter court authorized service. Default judgment is granted. Thank you, counsel.
Thank you.
And lastly, case number 2239-7112 LT, Bill Properties LLC versus Thomasine and Robinson, and occupants at 8986 North Martindale Street, Detroit, Michigan, 48204. May I have
Gabriel Lacy on behalf of Bill Properties, Your Honor, P 79685.
Thank you, counsel. Is Thomasine and Robinson here? Does anyone reside at 8986 North Martindale Street in the city of Detroit? Are the court aware that this notice is not defective? I was issued dated March 7th with my name as the judge and this court as the Zoom code. This case was adjourned for a second hearing, then adjourned for a third hearing back on the original second hearing date to ensure that defendant appears. Defendants failed to appear. Counsel, are you requesting a default judgment?
I am, Your Honor. The rent to retain possession is $1,215, cost of $160.75. Total owed of $1,375.75.
All right. I do have proof of service in the file. Any objection to an all occupants judgment, counsel?
Your Honor.
Okay. I'm going to do a March 27th move out date. So the rent to retain is $1,375.75. This is dismissal of named defendants and judgment for all occupants. And defendant by March 27th, 2023 or vacate.
Thank you, Your Honor.
You're welcome. Have a great,
have a good Friday.
Yeah, have a great Friday.
Thank you, Your Honor.
You're welcome.
Judge Sabree, this is Attorney Coleman. I wanted to knock out my two defaults and possibly talk to Ms. Gilbert.
Okay, can you hold on one second? That's the one in the courtroom I need to address. So maybe you can talk to Ms. Gilbert right now.
Yes, I can speak to Ms. Gilbert right now.
Okay, and then just let me know when you come out.
Okay, I just need you to invite us to a room so I can speak with her.
Okay, I'm going to invite you all to room number 11. Ms. Gilbert, we are going to invite you to room number 11.
Okay.
Okay, thank you, Judge. I see mine. I'll meet you there.
All right.
I had to give my boss notice that I was gonna take off for 2 days, you know what I mean? Because it said pre-trial.
And you're Miss Rosa Griffith.
I'm Rosa Griffith, but look at this mail, doesn't even say my name. There's no landlord, never.
So look, I'll call your case when Mr. Narcikian gets back in the courtroom. And I give you all an opportunity to talk. Because you're here and he's digital or remote, you're probably just calling from your cell phone. But I'll wait until.
Should I go back on when we get back in this room?
No, you're in the courtroom. You're here.
Okay. And I don't know who this person is. I mean, how do you fight somebody that just sending you mail? You know what, I'll be honest, I'm born and raised in Detroit. You just can't be sending people mail demanding like that, just saying things. I thought this was about my yard or the dog.
All right, we'll
Could
get
it
to
still
it.
be about that?
Oh, no.
I don't want to jump to conclusions, but no, I don't have a landlord.
I
No,
have an
there is no
assumption.
landlord lease, okay?
I have an assumption what may be the case, but I'm gonna wait until the case is called. Right, and I'll let you all discuss and hopefully find a resolution. In the meantime, sit tight. Would you like some water?
Yes, please.
All right, I'll get you some water. Wait a minute. Attorney Smith, good morning.
Good morning, Your Honor. Happy Friday. I am back on my 10:30 matter, ending in 470. It was adjourned out from Wednesday. It looks like the parties are here, and I was curious if the court would call it. And second of all, are we allowed to come practice in the court? Courtroom open?
Courtroom's open.
Wow. Okay, cool. Good to know.
Come down here. Your space.
Okay.
Yeah.
Oh, I get a tour? A special tour? Yeah, that's what I want. You will see me.
All right, I'll be here. So parties are ready on this?
I see my client, Robin Badon, and I see the plaintiff, Genevieve Douglas, in the gallery. She's unrepresented, so I would say yes.
Calling case number, did you speak to Ms. Douglas?
I haven't spoken to Ms. Douglas. I don't think we're going to reach a resolution.
Okay, I'll call it.
Okay.
Calling case number 2239-7470. This is Genevieve Douglas versus Robin Badon, and occupants on my screen.
Good morning, Your Honor. Hannah Smith, P86433, Lakeshore Legal Aid, on behalf of defendant Robin Badon. Ms. Badon, can you please state your name for the court's record?
Robin Badon.
Thank you, Mr. Don.
You're welcome.
And Ms. Douglas, can you state your name for the record?
Genevieve Douglas.
Thank you.
Your Honor, we adjourned this matter for the court to review defendant's answer and affirmative defenses to plaintiff's complaint. Today, we are here to argue the case and hopefully get a decision in this matter, a resolution.
How were those affirmative defenses presented?
I hand filed them with the court on March 7th, and then you sent me your email, so I emailed them to you, the PDF on Wednesday when we were in court.
Was it, okay, I have it.
Okay.
I'll recall this matter.
Okay, so we'll pass and wait, yes?
It will pass.
All right, sounds good.
I think I printed this out in my chambers. Want to print out first. 5 pages. 9 pages. Have the exhibits. All right, I'll recall it shortly.
Okay. My PDF is 27 pages with exhibits.
Yeah, I think the first 9 are the pleadings.
Correct.
Then exhibit 1 starts at 10.
Yep. Okay, thank you, Judge.
Thank you. So, Ms. Badon, I'm going to recall your matter, okay?
Okay,
You have some free time right now. Going to probably recall it in. We'll recall it shortly.
all righty. Thank you.
You're welcome. Check some of these names.
Oh, sure, Joe.
Make sure that people are not sitting in wrong.
Yeah, sure.
We have 2.
We've got someone that has a cell phone number ending in 6948. Do you have a case number by chance? Yeah, do you have a case number so I can make sure you're in the right place?
Yeah, I'm here.
Do you have a case number so I can make sure you're in the right place?
I don't have it on me. It's landlord tenant court against Ashley Tolbert and what's the lawyer name? Michael. Hold on, Your Honor. Case number 213-53015. Michael Lamb.
Okay, you're in the wrong courtroom. If you can grab a pen and paper, I can direct you to the correct judge.
Okay. Okay, I'm ready.
Okay, the Zoom number is 360. Oh, you dialed in. Don't know their dial-in number. I don't know their dial-in number since you called on a phone directly, but I can give you their telephone number. Write this down, 965
565.
2565.
2565.
Yep, your judge is Sean Jacque, Jacque. They'll give you the dial-in number to Zoom.
Thank you.
Who's that? I see India Perkins. Did we check you in for court today?
No, I don't think so.
Okay, do you have a case number by chance?
1 second. 22394-149.
Okay, you are in the correct courtroom either. If you can grab a pen and paper and I can give you the Zoom number.
Okay, I'm ready.
Okay, it is 360
Okay.
538 0000. Judge Sean Jacque.
Okay, thank you.
You're welcome. I read the letters that he described back that his gold hair was down 60 something. See James Barnes.
Right here.
Do you have a case number so I can check to see if you're in the right place?
What I've got is 223.
First off, you done what you done.
97149.
Need a lot of shine around you. Oh, he's fine. Okay. It's good dark. The women go out. You might fall. Okay, got you. You are in the correct place. Billy. You've been driving. Oh. You don't mention the boy, not giving him much credit. There's someone by the name of West. Did we check you in for court today?
I am checked in. Can you hear me?
Yes. What is your case number?
I don't have it in front of me. The judge has put it off till Narcigian gets back into the courtroom after 11 o'clock.
His case number ends in 7142.
Oh, okay, thank you.
I don't agree with it.
No, you got a crippled leg out. I was sent to attendant in a bed. And you are. Now, Eli, I think you gotta let this boy find his own way. He'll live it. I think he's got more to stand and give him credit. You see that? Well.
Yeah. Maybe the see though. Just one way or the other.
It's just the other one. But the bubble is brought to the mud. Where it happened was. Look. How'd you come to get your leg like this?
But I took sick when I was a little. Years later, it just got like that. The other was stronger. do it.
Feeling there's more to the story.
This message is for people age 50 and older. If that's you, then keep watching because this message can mean a lot to you and your family. What is it about? It's about guaranteed life insurance at a cost that fits your budget. In fact, it starts as low as $9.95 a month. The rate you start with is the rate you keep. It will never.
Mr. Barber, if you can mute your device so we can't hear your background conversations.
No health question.
Attorney Coleman, are you ready to proceed on some?
I'm ready to proceed on all of my matters, Your Honor. Either I worked out agreements or there should be defaults.
Okay.
You want me to give you some case numbers? You already got them in front of you.
Calling case number 22397868, the Property Shop versus Laisha Wooten, and occupants at 19792 Schaefer Road, the great city of Detroit, zip code 48235.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548, on behalf of the plaintiff, this matter before the court on a subsequent hearing on a non-payment of rent. Defendant has failed to appear. We're seeking a default judgment. The amount that's owed is $5,086. Court cost of $157 for a total amount of $5,243. We'd ask that the statutory time apply.
All right, I do have proof of service in the file. Court will enter a default judgment for $2,243 with the payer move date of March 27th, 2023. Any objection to dismissal of the named defendants, counsel?
If that's what the court wants, I mean, if that's on the court, if that's what the court is asking for. They have never appeared to court, so I don't know why you benefit for not showing up. So there's no objection, but I leave it. If that's what the court wants, I'll do it. If it's not what the court wants,
I just asked if the default judgment is granted.
Thank you, Judge.
Calling case number 22397869, Rhapsody LLC versus Juliet Gilbert and occupants at 12681. Is Juliet Gilbert here? I'm sorry.
Yes. Who's here, Judge?
I don't need to read your whole address then. Okay. May I have appearances, please?
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548, on behalf of the plaintiff. Ms. Gilbert, identify yourself.
Juliet Gilbert.
Your Honor, myself and Ms. Gilbert had an opportunity to discuss this matter. In this particular matter, we're dismissing against her and entering a judgment by hearing against all occupants. What is owed as of today's date is $1,650. Court cost of $157. The total amount is $1,807. Defendant would have until April 17th to pay or vacate the premises. Again, the case is dismissed against her. MCR 4.201 subsection I was explained to defendant. She was explaining that she has 3 business days from today's date to file a motion asking the court to reconsider this because I am an attorney and she is not. She also has 10 days to appeal to a court of higher jurisdiction, that being the Wayne County Circuit Court. Ms. Gilbert, is that the agreement that we worked out?
Yes.
All right, the court entered a judgment by hearing dismissal to name defendant. So Ms. Gilbert, your name is dismissed and the judgment will be entered for all occupants. However, all occupants must pay $1,807 by April 17th, 2023, or a writ may issue. Good luck, Ms. Gilbert. This concludes this matter and you are free to leave.
Alrighty, thank you, Judge. Have a good day. Thank you, Mr. Coleman.
It was a pleasure, Ms. Gilbert. You have a blessed day.
You as well. Bye-bye.
Bye.
Calling case number 22397871, Ivy Consulting LLC versus Andrew Barber and occupants at 3214 Lockwood, Unit 2F in the great city of Detroit. May I have appearances?
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548 on behalf of the plaintiff. Mr. Barber, please identify yourself.
Andrew Baber.
Your Honor, myself and Mr. Baber had an opportunity to discuss this matter. We have proposed agreement with the court. The agreement reads as such. There will be a judgment by hearing against all occupants. Case should be dismissed as to Mr. Andrew Baber. He will have until April 24th to either pay or vacate. The amount owed is $4,425. There are court costs and statutory attorney fees of $157 for a total amount of $4,582. MCR 4.201 subsection I was also explained. Mr. Barber was explained that he has 3 days from the day's date to file a motion asking the court to reconsider this because I'm an attorney and he is not. He also has 10 days to appeal to a court of higher jurisdiction. Mr. Barber, is that our agreement, sir?
Yes, it is.
And Mr. Barber, how do you spell your last name?
Boy, Apple, Boy, Edward, Robert.
Boy, Apple, Boy, Edward, Robert?
Correct.
All right, thank you. We'll correct that in the computer. You have, the court will be entering a judgment by hearing for termination only and non-payment of rent case for redemption amount of $4,500 and a move-out date of April 24th, 2023. So you can pay.
Did you say 4,582?
Yes.
Okay, you faded out on me on my end. Okay. Mr. Barber, it was a pleasure talking to you, sir. Wish you and your family well. Have a great weekend.
You too.
Thank you.
All right, you have a great weekend, Mr. Barber.
You too, Your Honor.
Your Honor, I have one more case with you today.
Is this a default as well?
Yes, Andrea Walker.
Yes.
No one's told me she's here, so I'm assuming it's a default, Judge.
Calling case number 22397872, the Property Shop versus Andrea Walker and occupants at 14950 Stouffville, apartment number 2 in the city of Detroit. May I have appearances?
For the record again, Attorney Frederick J. Coleman, P. 56548 on behalf of the plaintiff. This matter before the court is a non-payment of rent. You said the address for Andrea Walker, the amount owed is $9,385. Court costs and statutory attorney fees of $157 for a total amount of $9,542. At this time, the plaintiff is asking for a default judgment and for this amount to be paid in a statutory 10-day period.
All right, court will enter a default judgment for defendant's failure to appear. The redemption amount is $9,542 to be paid on or before March 27th. Defendant must pay or vacate by March 27th or a writ can issue.
Your Honor, it is always a pleasure. You and your staff and the remaining of the gallery have a wonderful day and a better weekend. We'll do this again on Monday.
All right, have a great weekend.
Thank you, Judge.
Mr. Johnson. Attorney Cohen and Jason Johnson. I see Mr. Narsigian.
Never met that name before.
Mr. Narsigian.
I have one that I know is ready to go, Judge.
Okay. Which one is that?
7141.
714. You also have someone here.
Yeah, Mr. Curtis, we spoke.
Mr. Curtis and someone here in the courtroom, Miss What's his name, ma'am?
Rosa Griffith.
Miss Rosa Griffith. Miss Rosa Griffith is here in the courtroom. She's on,
I never met this man before.
yeah, you all will meet Miss Griffith. She's on Vinewood and case number 149. So we
Okay,
can,
I spoke with Attorney McCarty on that one. I think we have a resolution there as well.
And I'm sorry, Your Honor, Rosa Griffith, I don't believe that she's not the person I was speaking with. I was speaking with James Burns, who's in the courtroom for Vinewood, 1427, even though I think it says 72 on the, it's supposed to say 27. I think we discussed last time that it was a clerical error on the court's part. Mr. Narsigian filed the correct paperwork with 1427 Vinewood, but for some reason it was 1472 Vinewood in the court records and on the ROA.
1427 Vinewood.
It's how you say it.
Hold on. Let's call this and get her out of here. Ma'am, could you approach the podium? Back to your Friday.
I gotta put this on. Honestly, I don't like breathing this.
Okay.
But I'd like to know this man to see who, because I don't like this man. I don't like these procedures.
Officer, can you scoot over just a bit? Thank you. All right. Calling case number 22397149. This is DRF5QOZB LLC versus all occupants at 1427
Wait a minute, I'm not a 142.
Vinewood, Detroit, Michigan, 48216. May I have appearances?
Sean Norsegian, P77410 on behalf of plaintiff.
Thank you. And ma'am, can you state your name?
My name is Rosa Griffith of 1472 Vinewood, Detroit, Michigan, 48216.
Okay, and so to make the record clear, you do not reside at 1427 Vinewood in the city of Detroit.
No, Your Honor, I do not.
And for the record, the Register of Actions says 1472 Vinewood, which is your address, Ms. Griffin?
Yes.
And that's what prompted you
To come here today, yeah, you used my address, yeah.
Okay, and I believe it was a typo because the complaint and the notice says 1427.
Thank you, thank you.
And the Register of Action says 1472. So is this matter, are you continuing this matter, counsel?
I'm continuing against 1427. 1472, we have nothing to do with her and I didn't send her anything. So, you know, she's.
You want to see my mail?
Did you receive a summons and complaint?
I got it right here, buddy. I wouldn't have came down here otherwise. I got mail.
Like a lawsuit, or was it just a notice?
No, it was just a notice that said, 3 notices in 4 weeks. The last one was Friday, said come here, and no anything else, just the paperwork. It said, it didn't tell me why I had to come here. But to respect as an American citizen, I want to respect the court.
We appreciate that. The court appreciates you
Oh,
appearing and clearing this up. And this is clear. This case is not towards 1472 Vinewood, but actually against 1427 Vinewood. So is there anyone in this courtroom or in the Zoom room that resides at 1427 Vinewood?
Yes, Your Honor, there is James Burns. He's unmuted.
It's James Burns. I reside there.
Okay. Mr. Narsigian, did you talk to Mr. Burns?
I spoke with Attorney McCarty and we came to an agreement.
Okay.
And I spoke to Mr. Burns about the case.
All right, Mr. McCarty, did you put your name on the record yet?
I have not, no.
All right, could you state your name for the record?
Yes, Your Honor. Donovan McCarty, P80907, on behalf of the occupants at 1427 Vinewood in Detroit.
Thank you. Would you like to put the terms on the record, counsel?
Yes, Your Honor. Mr. Narsigian, are you okay if I?
Yeah, go ahead.
Okay. I spoke with Mr. Narsigian, I spoke with Mr. Burns. We have agreed to move out date of May 2nd, 2023. And those are basically the complete terms.
Okay, and is there any objection to the judgment being entered as all occupants?
No, Judge.
We're going to dismiss the named defendant. I don't think there was any named defendant in this case.
No.
So we'll keep it as it is, named defendant for all occupants for this is a termination of tenancy case to vacate by May 2nd, 2023, or writ can issue. Are these the terms that we understand to be the agreement?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you, counsel.
Your Honor, may I ask, do I email this to someone or is there a fax number?
I'll send you the fax number.
Okay, thanks.
All right, thank you. And you are, ma'am, you are free to leave.
That's it.
That's it.
You don't want to give me a paper?
I'll give you anything you need for work. If you need
Right, I
something for
didn't miss work, you know what I mean? And you know what, the boss says, you don't have to, it's a phone call thing, and I go, you know what, in the Renaissance, the phone never works.
All right,
I
well,
got nowhere.
thank you.
Thank you, but are you sure they're not gonna try to keep some of that nature, right?
They're not gonna try to kick you out of your house or anything of that nature.
It was a pleasure, sir.
All right. So, Mr. Narsigian, was the other adjourned matter for the property on Burns already transferred out of my court?
The property on what street?
Remember Burns?
Burns.
Or is it conflict?
Oh, so that one's interesting. I have a feeling that one is going to be, I mean, your dad actually called my client, as weird as that sounds. So I think that they're going to work with the city in getting them the property back, but nothing has been resolved at this point.
Okay, because I was going to remove myself from the case, but I'll wait. I thought it was popping up today.
No, it's on the 21st, Your Honor. But like I said, I mean, really what it comes down to is, even though my client thinks that they own the property, I mean, they want to maintain a good relationship with the city. So my last conversation with them made it seem like they're working it out with the treasurer's office right now. So we'll probably have some sort of agreement or a dismissal for you at some point.
Right, that's better news than I was expecting. So, all right, yeah. Sometimes stuff gets a little coincidental or cloudy, but, all right.
Yeah.
Do you have any other defendants here?
Yeah, I do. Case ending in 7141. Mr. Curtis is here.
Right, Mr. Curtis. I'll call that one and then I can call your default.
Great.
On case number 22397141, this is DRF5 QOZB LLC versus all occupants at 3806 Grand. May I have appearances?
Sean Norsegian, P77410 on behalf of plaintiff.
Michael Curtis. Good morning, Mr. Curtis.
Good morning.
Have parties reached a resolution in this matter?
Yes, Your Honor. We've agreed to a judgment by hearing. Mr. Curtis's name is not on the lawsuit, so he's not on it at all. It's all occupants, and with a move-out date of May 1st.
All right, Mr. Curtis, do you understand what's going on?
Yes, sir.
All right, so a writ can be filed with the court on May 2nd. And that would legally give plaintiffs, this is plaintiff's attorney, but it'll legally give plaintiff the right to conduct an eviction with the bailiffs. As long as you vacate by May 1st, a writ won't issue. The judgment isn't in your name. Wish you luck and have a great weekend.
You too.
Thank you. Calling case number 22397143. This is DRF5 QOZB LLC versus all occupants at 4706 Somerset in the city of Detroit.
Sean Norsegian, P77410 on behalf of the plaintiff.
Thank you, Mr. Narsegian. Does anyone reside at 4706 Somerset in the city of Detroit? Counsel, you may proceed.
Your Honor, we haven't heard from the occupants. We're asking for a default judgment, the move-out date of March 28th.
Defendant failed to appear. This is not a named occupant, but any occupant at 4706 Somerset who received the notice that was issued on March 7th, 2023 to appear on this date, failed to appear on this date. So the court will enter a default judgment. This is a termination of tenancy with the move-out date of March 27th, 2023. On case number 22397145 DRF5QOZB LC versus all occupants at 8424 Plainview in the great city of Detroit. May I have your appearances?
Sean Norsegian, P77410 on behalf of plaintiff.
Thank you. Does anyone reside at 8424 Plainview in the city of Detroit? Counsel, defendants have failed to appear. Are you requesting a default judgment?
Yes, Your Honor, no communication.
All right. This is a termination of tenancy matter. There's proof of service in the file. Defendant failed to appear. Court is granting a default judgment for plaintiff with a move-out date of March 27th, 2023, or writ can issue thereafter. On case number 22397147. This is DRF5 QOZB LLC versus all occupants at 1514 West Philadelphia in the city of Detroit. May I have appearances?
Sean Norsegian, P77410 on behalf of the plaintiff, Your Honor.
Thank you. Does anyone reside at 1514 West Philadelphia? Defendant has failed to appear. This is a second hearing, actually a third hearing for termination of tenancy matter. There's proof of service in the file. Counsel, are you requesting a default judgment?
Yes, Your Honor, I am. No communication.
All right, the court will enter a default judgment in favor of the plaintiff with a move out date of March 27th, 2023, written, and it may issue thereafter. Calling case number 22397148. This is DRF5 QOZB LLC versus all occupants at 15881 LaSalle Boulevard.
Sean Norsegian, P77410 on behalf of the plaintiff.
Thank you. Does anyone reside at 15881 LaSalle Boulevard? In the city of Detroit. This is a second, technically third hearing for summons and complaint for possession of property, determination of tenancy matter. There is proof of service in the file. Defendant failed to appear. Counsel, are you requesting a default judgment?
Yes, Your Honor. No communication with the defendant.
All right, the court will enter a default judgment with a move out date of March 27th, 2023, or a writ may issue. That conclude? Oh no, we have one more.
Yeah, we have one more with the gentleman is here, Mr. West.
Mr. West, yes. Miss Attorney Smith.
Yes, Judge.
I'm going to hear your matter after I hear Mr. West. I have Jason Johnson as well. I think we have a resolution on Jason Johnson. So we'll do West, Johnson, and then there are only two more cases. Is Eddie Turner here or Terry McFarland? Terry McFarland is here.
Terry McFarland is here.
All right, have you talked to Eddie Turner?
We made arrangements and I've been keeping up with my payments, so we haven't had any problems.
All right, because he's not here.
Oh,
So I'm
okay.
inclined
What
to
should I do? What should I do?
calling case number 22397130. This is Eddie Turner versus Terry McFarland. Can you state your name for the record?
Terry McFarland.
And Ms. McFarland, did you receive notice to appear in courtroom 436 this morning?
Yes,
And how did you receive that notice?
by mail.
Okay, it was mailed to the address on Stansbury?
Correct.
All right. Court is aware that there's a notice issued March 7, 2023 to appear for today's hearing at 10:01 a.m. This was previously adjourned. Plaintiff Eddie Turner. Eddie Turner here. Plaintiff Eddie Turner has failed to appear. However, Ms. McFarland is present in the courtroom. Are you requesting, Ms. McFarland, that this matter be dismissed?
Yes.
All right, this matter is hereby dismissed without prejudice. That means that the plaintiff can refile if they choose to refile. However, it would be in a separate action that must be refiled with the court. To appear as a practical, in a practical sense, Ms. McFarland, whatever you are doing, whatever's working, continue to do it. Continue to do it. Okay. You all have a good relationship, maintain that good relationship. But as it goes to you being obligated to reappear in court, that obligation doesn't exist anymore as it relates to your landlord tenancy on Stansberry. So, if that failure to communicate, if you all fail to maintain whatever relationship you have going on or whatever payment arrangement, he may refile. But this case right here is dismissed. Okay?
Okay. Thank you, Judge.
You are welcome. Plaintiff failed to appear. This matter is hereby dismissed. This resolves the last pending claim and closes the case. The court will send out copies of the dismissal to both parties. You are free to leave, Ms. McFarland.
Thank you.
Have a great weekend.
You also.
All right, thank you. All right, Mr. Narsigian, I'll call your case. And for the attorneys, if you are submitting by email, please put the case numbers in the subject line so they're searchable. Jason Johnson, are you ready to go? Are we waiting on? Okay. Attorney Cohen, are you ready?
Yes, Your Honor.
I can call. I'm take a. Okay, 3 minutes left. What'd you say, Mr. Johnson?
I said I'm ready, sir.
Okay, do you have counsel?
Trying to do a group back on January 13th on this case?
Yes, ma'am.
Okay, you the attorney or representative on that date.
That sounds like she.
Hello, hi, I'm here, sorry.
Okay.
Carolyn
Are you ready?
Cohen, P49391, appearing on behalf of the plaintiff. Mr. Johnson originally talked to somebody from one of the legal aid attorneys. The legal aid attorney said she wasn't representing him, and she had me try to talk to him. We were not able to reach anything and any agreement, and I'm asking for a judgment today. He disagrees. I can't give him he agrees with the rent that's owed. I mean, and there's just, there was a breakdown in terms of our trying to negotiate, and I'm just looking for a move out date.
Okay. Calling case number 2239743. This is River Place Apartments versus Jason Johnson and occupants in River Place Drive. Mr. Johnson, can you state your name for the record?
Johnson.
It may help for you to cut off your video.
Yes.
So then I think it'll be a clearer connection. All right. Parties, Attorney Cohen, you already noted to the court that parties attempted to work this out. Mr. Johnson, is it your intention to remain in the property?
Yes, yeah.
Are you driving right now? That leads to a bad connection.
No, sir. No, sir.
Okay. All right, I can hear you better. You want to remain?
No, sir, I'm not driving.
Okay. How much rent is owed?
$5,969 in rent, $159 in court costs, for a total of $6,128.
6,128. Okay. Mr. Johnson, when can you make when can you pay this amount?
I was looking to set up an arrangement. We originally agreed upon March 31st of $3,000. And also just making sure the repairs were met by that time as well. And that's something that we agreed upon. Or I can do 1,500 on the 27th, and then another 1,500 on the 5th. And then the remaining balance, I can make my on-time monthly payments with an additional, I think we agreed on 381 added to each monthly installment.
It was 391, and I'm willing to do that. But when I had the discussion with Mr. Johnson, I explained to him as part of the conditional dismissal, I would need him to say that he agreed to pay, his April, May, June, July, the next months plus the 391. And that's where he said he wasn't going to agree as part of this agreement to pay, future months of rent.
Okay, so since it sounds like you all are in agreement, Mr. Johnson, do you intend, what's your monthly rent?
$1,689, I believe.
It's 1685.
Okay, 1685. So are you agreeing to pay 1685 plus 391?
Yes, I think the confusion was whether or not the repairs were going to be made by the first installment of 3,000. We originally agreed on that, and then it was taken away. And
What
she wanted me.
What repair issues do you have?
My patio door won't close. It's hanging off the hinges. The building is fully aware of it. They're telling me that they can't have it done until spring. So I was just asking for some sort of concession in order to pay my remaining balance, some sort of arrangement, but we weren't able to reach one with Ms. Cohen.
All right, so what, your patio door won't close? Is it the screen or the actual door?
It's the screen, the door, the brackets on the door are bent. So it's preventing the door from being closed. At times it's being maintenance. They held it together with just a screw. So it's kind of causing I told Mrs. Cohen that it's causing my DTE bill to skyrocket. We've been experiencing some cold weather temperatures. So it's been causing financially kind of a strain on my finances. I'm definitely able to make some sort of payment. I was just asking for some sort of concession, seeing as they can't fix the patio door until spring, I think Ms. Cohen said.
Yeah, what did maintenance say?
Yeah, I talked to them. There's a project that has to be, it's partly the patio and partly the door, and they are aware of it and they have people scheduled, but unfortunately, because of the coordination of these two efforts, it's not going to be completed until, I got my area director on the phone until the spring.
All right, so how much would you say has been increased? How much your DTE bill increased? And how long has this issue existed?
The issue has been existing for about a year now. And the building, they've been out. Like I said, they put a screw on the door to kind of patch it together.
How much of a difference? How much of an increase in your DTE bill?
At least, I'm looking at least $100 in addition to my standard bill. You got to keep the heat on 24/7 in order to, contain some sort of heat in the home. So at least $100, Your Honor.
Okay, and the first payment. So are parties in agreement with the conditional dismissal? Your repairs will be made. The court will reduce your rent by $100 to $1,585 until the repairs are made. So what would, see, how much rent, how many months of rent is owed? Let's see. I'll do a of $100 for November, December, January, February, March. I just don't want to throw off your payment agreement.
So you're reducing the amount by $500?
By $500.
Okay, so you're reducing it by 500 and then that would be, let me just reduce this, 964. Okay, that would be 5469 in rent and 159 in court costs. So let's do that, 5469 plus 159. That's 5628.
That's what I have.
Okay, there's a total of 5628. I guess, I originally had told him, we went through some different scenarios. Now that there's less that's owed, I mean, I guess I would like half of it by the end of the month, and then he can have a payment arrangement for the other half.
How's that sound, Mr. Johnson?
What was that total again, Your Honor?
5628 is the total, including court costs. Half by March 31st. Do we have a March 31st? Yep. Half by March 31st. Balance on the payment plan, Council?
Yeah, so that would be, we'll do a 6-month payment plan. the balance would be 2814 divided by 2. I'm sorry, 2814 divided by 6. He'd be paying an additional $469 a month.
Your Honor, originally, we agreed upon 1,500 on the 27th and then another 1,500 on the 5th. And then 381 in addition to the monthly payment.
Yeah, 391, but I also reduced your amount by $500. So this may have accelerated a little bit. So do you want to agree to this?
No, I haven't.
All right.
So by the 30th, you're saying you would need $3,000?
No, 2,814.
I was up until
half of the 5628, Johnson.
because I hadn't been able to do it.
Okay. Is there any way to get an extension, maybe 10 days? 15 days?
I'm not agreeing to the extension.
March 31st. All right. If parties can't come to an agreement, the court will enter a judgment by hearing for non-payment of rent, a dismissal to named defendants, and judgment for all occupants. Your name will be dismissed as a named party. Defendant will need to pay $6,128 or vacate by April 14th. Parties can work out an agreement In the meantime, make sure you get it in writing, Mr. Johnson.
Thank you.
You're welcome. So is the
I'll
judgment
submit
by
that to the court. Thank you.
You're welcome. Thank you, Mr. Johnson. Have a great Friday. So you need to pay $6,128 by April 14, 2023. The defendant, your name will be dismissed as a named party. The judgment will be entered into all occupants. You can work out an agreement. Sounds like you all are pretty close to working out an agreement. Work it out in writing before April 14th. That concludes this matter. Thank you, Mr. Johnson.
Thank you, Your Honor.
You're welcome. Have a great week. Have a great weekend, Attorney Coleman.
Thank you. You too.
Calling case number 22397142. This is DRF5Q0QOZB LLC versus James West and all occupants hence at 15335 Wilderness.
Sean Norsegian, P77410 on behalf of plaintiff.
James West, appearing as pro se, Your Honor.
Thank you, Mr. West. Today is the date and time for an adjourned hearing to address defendant's motion to dismiss. Court is in receipt of the motion filed. Opposing counsel is also in receipt of the motion filed. So, Mr. West, this is your motion.
Very well. Your Honor, let me open up by stating that I am a student of human rights law and a student of indigenous law and international law, as well as domestic law. I'm actually planning attending law school to join you guys in the bar in the near future. So the way that I had to frame this case was because of the nature of the summary proceeding. And I know this is not how it's normally done, but it was the only way that I could think of to do it. So bear with me. There may be a few glitches here and there pertaining to the case. But my motion to dismiss is based upon MCR 4.201, in particular, Section D. I'm the only person that could have received personal service. Now, I know that the court says it has proof of service on file, but I have not seen that, nor have I seen or had an opportunity to cross-examine whoever said they served me personally or any occupant. And that's the reason I'm dismissing the case, because 4.201 Section D says that it must be served in a manner or upon someone in the household of suitable age, and the content of the service must be revealed to them. And that has not been done.
What about 4.201 D3? What does that say?
I don't have the statute in front of me, Your Honor.
Read it. I'm gonna read it for you. 4.201 D3 says, after diligent attempts at personal service have been made. Okay.
That's right. That's right. In addition to
by securely attaching the documents to the main entrance of the tenant's dwelling unit. A return of service made under this sub-rule must list the attempts at personal service. Service under the sub-rule is effective only if a return of service is filed showing that after diligent attempts, personal service cannot be made. An officer who files proof that service was made under the sub-rule is entitled to the regular personal service fee. So,
right.
I have a proof of service for this matter served by Carlton Carter, the court officer at 36th District Court, that states a diligent attempt was made on December 19th, 2022 at 8:51 a.m. Another attempt was made December 23rd, 2022 at 6:13 p.m. Switch the time up. And the last attempt was made on December 28th, 2022 at 12:44 p.m. So
Okay, well, diligent attempts is not serving or attempting to serve 3 times. Diligent attempts, according to the legal literature, actually means that you tried to find the defendant's job where he worked at.
no,
And
we're not making up new definitions.
I'm not making up any either, Your Honor. I'm just explaining what the legal literature says. A diligent attempts doesn't mean.
What literature are you quoting? What legal literature are you quoting?
Just over the years of studying this, I've done this. I've done.
Hold on, Mr. West. I'll let you talk.
Okay.
I need a citation. I need you to cite this. We can't. This sounds like a little bit of barbershop talk. If I don't have a citation, then it may not be legal literature that's applicable to the Michigan court rules or, the state of Michigan or the United States of America.
Okay, well, we can check juris secundum or am juris. That's the legal literature that I study.
Today's the day and time for you to argue your motion, and based on MCR 4.201 D3, diligent attempts were made. Affidavit was filed. Service is proper. Now you can appeal that hearing. However, I'm granting proper service. Now you had a motion to dismiss for insufficiency of process of service. So that is one that you can appeal, but I'm denying that motion to dismiss on those grounds. But
okay,
you have
Judge, if I can,
go ahead.
Mr. West, we do have legal aid here available. If you'd like to speak to an attorney from Lakeshore Legal Aid about your case, we may be able to help.
We're in the middle of the case.
I'm sorry, Your Honor, I didn't hear what you said. I heard some gentleman come in.
Mr. Narsigian, do you have anything to say?
I agree with everything that you said, Your Honor, regarding the service. As far as the rest of Mr. West's claims, while I wish he was right, it would be great if we didn't have to pay property taxes. The fact is that we do. So that's
objection, Your Honor.
Position.
Objection, Your Honor. That's beyond the scope of the pleadings. The attorney filed a landlord tenant case. This is not about taxes. So on his complaint, he has something about that in section CH on his complaint that my lease was terminated. There's no evidence in the record about he and I ever having a lease. So he's flipping the switch and talking about taxes. He said that I am his tenant. That's not the case at all.
This is not saying that. This does not say that there was any lease that existed. I don't think there is any allegation of a lease existing. So, okay. Motion to dismiss for fail. Let's get to all these. On page 12, that was your motion to dismiss for lack of personal jurisdiction. So, have we established the fact that MCR 4.201 D3, we've established the fact that diligent attempts were made according to the affidavit stated by Carlton Carter that service is proper by attachment. So you have other motions. You have a motion to dismiss for failure to state a cause of action, lack of subject matter jurisdiction, petition for a temporary injunction. So which one would you like to argue next?
Well, no cause of action, in part because I have no agreement, never had an agreement with this corporation or the attorney, none of that. And again, he's alleging that this is a leasee complaint. So he must prove that. I don't see any evidence that he and I ever had any agreement.
Mr. Narsigan?
At no point did we allege that this is a leasing lessor situation. The property was purchased at tax auction in September of 2022. The deed was
Objection, Your
recorded-
Honor. Again, this is beyond the scope of the pleadings.
Oh,
This
no,
is this is not a tax case.
that's the beauty of this, Mr. Narsigan, please continue.
Okay, so the deed was recorded October 6th of 2022. I believe at some point in November, we sent a 30-day notice to quit so we could gain possession of the property. Obviously, self-help is not a remedy in Michigan, so we can't, kick him out of his own house. We go through the eviction process, and that's where we are. This was a summary proceeding that we filed. We provided him with a 30-day notice to quit. He didn't move. We filed the case. I think this is the third hearing that we've had now. We're, 6 months past when title passed to my client at this point. So we have standing to file the case. And there's no need for a landlord-tenant relationship in order to file an eviction case. And that's our position.
I'm gonna unmute you, Mr. West. Well, I'm asking you to unmute. Mr. West? Mr. West? Mr. West?
Can you hear me, Your Honor? I'm here.
I can hear you. Can you
Yes.
put your camera?
Say that again, Your Honor. There's some interference.
I was asking, could you put your camera up, but you can continue.
Okay. Once again, Your Honor, I haven't heard the plaintiff state any law that he's standing on. This case, he's still talking about what happened at an administrative hearing. The court here doesn't have any jurisdiction to hear any administrative hearings.
Hold on. Let's rewind that.
Okay.
Are you referring to Wayne County foreclosure?
Yes, all of that. Yes, Your Honor, because the court only has jurisdiction.
Hold on, please.
Oh, God.
The Wayne County foreclosures occurred in Wayne County Circuit Court. It's not an administrative court. It is a circuit court filing that Wayne County files against the landowner or the property owner. These are Wayne County Circuit Court cases. And yes, that's jurisdiction, but that's the reason why this case was filed. This case was filed because plaintiff obtained a deed from the Wayne County auction. Whether he obtained it from the Wayne County auction or obtained it from someone who sold him the property, he has a deed. That deed states that he owns the property of 15335 Wilderness. By law, anyone who has a deed may file an eviction. There's not a requirement that someone has to have a lease to file an eviction. This matter was filed as a complaint to recover possession of property. There's no allegation when you file a complaint to recover possession of property. There may be an allegation of a lease expiring, but based on the complaint, 5B was checked. As you noted, because you're aware of the complaint, because you quoted the complaint. 5B states that tenancy was terminated by notice to quit. What is the notice to quit? The notice to quit is the notice to quit to recover possession of property that was issued on October 24th, 2022, before this lawsuit commenced. So That is why the Wayne County auction is being referenced. There is no need to quote any law. This is just a story, a factual basis that establishes why we are here, why a complaint was filed to recover possession of property, and why Mr. Narsigian, on behalf of his client, has the right to file a complaint in this courtroom to gain possession of these premises.
I'm going to object, Your Honor, because I'm going to object on the grounds that the foreclosure process starts with an administrative proceedings. That's with your father or the tax assessors, and then your father attempting collecting the tax and showing, or not your father, but the Wayne County treasurer attempting to collect the tax and have a show cause hearing. That's the administrative part of this process that I'm referring to. So
what
now,
does that have to do with us right here? What does that have to do with anything?
all of that's interrelated in the sense that because that was an administrative proceeding, that this court judicially only has judicial power to review whether those proceedings were done properly.
I don't have any power to review anything that's going on in the upper court.
That's my point. That's why I said he doesn't have any cause of action and the court has no jurisdiction.
The court has jurisdiction. This is the exclusive jurisdiction to hear landlord-tenant cases. Any property in Detroit with a parcel ID within the limits of the city of Detroit goes to landlord-tenant court. If I'm in Highland Park trying to evict someone, I can't evict them in 36th District Court. I have to go to Highland Park. If I'm trying to do it in Ferndale, it's not an Oakland County court. It's not Royal Oak District Court. It's going to be Ferndale District Court. This works for the entire state of Michigan and most likely the entire United States of America, because county courts won't have jurisdiction over local matters. And this here is a local matter. So I'm going to deny your claim for your motion to dismiss for failure to state a cause of action. So I've denied your claim for failure for motion to dismiss for lack of personal jurisdiction. We've got it established that this is proper jurisdiction and service by attachment is proper, and personal service is not necessary in the landlord-tenant court, especially for a termination of tenancy. It's not a money judgment attachment. Court rules don't require personal service. Lack of subject matter jurisdiction. This is your final motion, I believe. So please argue.
Well, it's all related upon the service of process, and you've already made a ruling. So you can just go ahead and make your ruling on the subject matter jurisdiction.
Okay. Said pursuant to MCR 2.116C 4, 5, 6, 7, 5, 6, 8, 9, and 10, the court must dismiss this case. What is MCR 2.116? You drafted this.
I don't have it in front of me, Your Honor.
I do.
Okay.
MCR 2.116C says the motion may be based on grounds of one of these grounds, but must specify the grounds on which it is based. Court lacks jurisdiction over the person or property. Exclusive jurisdiction over the property. The process issued in the action was insufficient. We just went over that service was proper according to MCR 4.201. So C2 won't work. C3, the service of process was insufficient. No, that's not a ground. Court lacks jurisdiction over the subject matter. This is the jurisdiction for an eviction landlord tenant court. Doesn't get any better than this, the subject matter jurisdiction.
Well, he's raising a tax issue.
He's not raising the tax issue. The party asserting the claim lacks the legal capacity to sue. The party has the legal capacity to sue.
Okay, well,
Six,
go ahead.
other action has been initiated between the parties involved in the same claim. Mr. Narsigian, is there another pending matter related to this case?
Not to my knowledge and not that I filed.
All right, you didn't plead 7, you pled 8. The opposing party has failed to state a claim on which relief can be granted. Relief could be granted by entering a judgment in favor of the plaintiff. So that doesn't work. 9, the opposing party has failed to state a valid defense to assert the claim asserted against him or her. You have to argue. Do you have any argument? For 9?
No,
Are you gonna let the pleadings speak for themselves?
exactly. Yes, Your Honor.
Okay. And except as to the amount of damages, there is no genuine issue as to material fact. There's an issue of material fact. So I'm going to deny your motion for lack of subject matter jurisdiction. Clause 3, Michigan Constitution 1963, Article 628 says that this court has no power to review administrative action. You might be right on that, but this is not an administrative action, and we're not reviewing the merits of a foreclosure. I'm presented with a deed, a notice, summons and complaint.
And Your Honor, just to be clear for the record, although foreclosures might start as administrative actions, they are processed through I know you know this, but just for the record, they're processed through the Third Circuit Court. There's a case number that's issued. And so it is a judicial action when the foreclosure is issued. And yeah, that's it.
Okay. Yeah, and the court understands it may start as a judicial action, but the foreclosure, as you stated, is a circuit court lawsuit with the case number. So, in order to adequately address your filing, you have a counterclaim. You're also suing. Counterclaim, there's count 1, count 2, count 3, and count 4. Do you want to argue your counterclaim, Mr. West?
Actually, I want to start with the my answers to the defendant's complaint.
Well, the court has then proceeded in answers to the complaint. It's not, I'm not ruling on your answers. Counterclaim number 1, sham. The defendant commenced a complaint claiming to be a lessor of the defendant. Defendant did not file a false complaint. Just wanted to clear this out. All right. Mr. West?
Yes, sir.
Do you have any other arguments for the court?
The counterclaim is basically based upon the claim that the plaintiff is the lessor and I'm the lessee.
It's not, he's not alleging that.
The first count.
Okay, well, yeah, that's irrelevant because it's been established today that that isn't alleged in the complaint. That's not the allegation in the complaint. So you may say that H7 or box 7 that declares that this residential property was fit for intended use and has been kept in reasonable repair during the term of the lease. That doesn't imply that there's a lease. You can appeal that ruling, but the complaint states that you're here because tenancy was terminated by notice to quit. That's the
Well,
allegation.
why doesn't
So-
box 7 apply? It's checked off.
The Scrivener's error, Your Honor.
Okay.
That's why this is a sham pleading. Now that was an error. Okay.
It's an error. It's an alleged error. Hey, go ahead, Mr. Narsigian.
I
Go
was just
ahead.
gonna say, all due respect to Mr. West at this point, I have other cases in another courtroom that are about to be dismissed by Judge Sherman. And I mean, this isn't a sham. This is a legitimate complaint. Everything was done properly in this. I'm more than willing, out of respect to the hard work that Mr. West did on his motions, and I do respect what he did there. I'm willing to give him until May 1st to move out, which I think is more than the statutory 10-day minimum. That being said, I mean, that's all I have to say.
And Mr. West, do you agree to the move out date? May 1st?
Your Honor, there's some issues relating to my rights to own my property alone, which is an international issue.
All right, the court will enter. This is what it's going to do. The court's going to enter a judgment by hearing for termination of tenancy. There's proof of service in the file. Mr. Narsigian, when you forward over I did receive previously had a copy of the deed, but please forward that deed over with your judgment.
Yes, Your Honor.
The court is making a determination that there will be a judgment entered for all occupants with a move out date of May 1st, 2024. So must vacate by May 1st, 2024. That's the determination, is the final determination of the court. Thank you, Mr. West. The court has reviewed your pleadings and considered your pleadings. And
I have an injunction. I have an injunction before the court as well.
well, the case is, the court is going to deny, the court is denying that injunction. Counsel.
How can you deny an injunction? It's a complaint.
I've denied your other complaints as well, but you may appeal this at the higher court.
All right.
All right. Good luck. Have a great weekend.
Your Honor, before you go, I have some objections that I wanted you to rule on. I've written them out. Do you have that? Are you in receipt of that?
No, this matter is concluded, Mr. West.
Okay. All right.
Thank you. Calling case. Court's gonna take a 2-minute recess, a 5-minute recess, and then call this final matter. Mr. Hill. Are you expecting to be heard in the courtroom?
Yes, I got a matter with Ashley Tolbert for 17675 Hoover, Detroit, Michigan. And her attorney is Michael Lee Lamb. My case number is 213-53015.
Can someone we'll try to find your proper courtroom. We only have one case left in here.
Okay.
Judge, I've been trying to chat him forever, tell him he was in the wrong place.
Where's he supposed to be?
Judge Sean Jacquet.
Mr. Hill, you have to go to 538.
538.
And 360-538-0000.
Can you repeat that one more time, please?
360-538-0000. So you're in 360-436-0000.
Okay,
All right, sorry for the confusion.
no problem.
Thank you, Judge.
You got him there over here.
Right there.
Sweet. Gold mine back 5 years ago.
Oh.
Worth $20. Oop. All right. Party's ready on Douglas and Badon.
Yes, Your Honor.
Calling case number 22397470. This is Genevieve Douglas versus Robin Badon and all occupants on Leslie.
Good afternoon, Your Honor. Again, for the record, Hannah Smith, P86433. My client, Robin Badon, is present in the Zoom gallery.
Can you state your name for the record, Ms. Badon?
Robin Badon.
Thank you. And Ms. Douglas, may I have your appearance? Ms. Douglas?
I'm sorry, I couldn't unmute. I'm here, Genevieve Douglas.
Thank you, Ms. Douglas. Parties reset this matter for today because court wasn't in receipt of defendant's answer and affirmative defenses to plaintiff's complaint. Thank you, Attorney Smith, for drafting this. The court had a chance to review it once, gone over it again, and there are several allegations and affirmative defenses that have been pled. So, counsel, well, I'll start with Madam Plaintiff. Has anything changed? Are you still seeking an eviction right now?
Yes, Your Honor, and I also brought over some paperwork from yesterday. I wanted to make sure you got it.
Was it a quitclaim deed, covenant deed?
No, that was already sent. I sent over a before you told me to put it, let you know what I was referring to, and I sent over about like 6 pages. I took them over there yesterday and asked them to give them to you.
Okay, are these the letters to Ms. Douglas?
I'm sorry, would you say that again, please?
Are these the letters that you sent to Ms. Douglas? I'm sorry. No. Okay. I'm looking at this. Must be.
It should be a packet of about 6 pages. It's it shows some receipts. It shows the copy of the letter that Ms. Badon gave to me. It also has a statement, a 2-page statement.
Okay, I think I see it. And so
Your Honor, I am not in receipt of what Ms. Douglas is referring to. I haven't seen any of that. And as far as I know, I haven't gotten any mail to my office.
All right, so the property isn't in code, but the all right, Ms. Douglas, are you able to make improvements, the necessary improvements to your property?
I cannot make the improvements with them in the house, Your Honor. Part of the problem, not only dealing with the fact that they're so far behind in the rent, is I have attempted to send people over to the house. They don't answer the door. They locked me out when I tried to go over to the house. I asked the daughter to clean up the house. Jessica, she told me to not question her lifestyle. I need to be able to make the corrections that the city is referring to. I cannot with them there because they're part of the problem and not the solution, just by virtue of how they got the house. It is totally dirty, it's unsanitary, there's trash all around the walls. I need to be able to.
Ms. Douglas.
Yes.
Is it safe, is Ms. Baden, Ms. Badon, or anyone at Leslie allowing you to enter the premises?
I'm sorry, I didn't understand that.
Have you been allowed to enter the premises to make repairs?
I haven't. The last time I went over there, the daughter, Jessica, came to the door. She stood at the door with the security door locked and wanted to know what I wanted. I did not argue with her because the last time I talked to her, it's constantly a battle. So I told her I just need to get my air conditioner. She drug it to the door to keep me from coming in.
All right, what have you requested to make repairs?
I've already prepaid for the lead inspection. However, I had to cancel because I can't afford to fail. And I can't
answer the question. Have you requested to enter the home?
Yes.
Okay, when's the last time you requested to enter the home?
I want to say maybe, it might have been maybe about 3 weeks ago when I talked to the daughter.
And before that, had you requested to enter the home?
I have not, I can't remember the last time I requested before that.
Okay.
Your Honor, can you please swear Ms. Douglas in so I know that this is under oath testimony?
Ms. Douglas, do you swear to tell the truth and nothing but the truth?
I do.
Thank you.
Ms. Douglas?
Yes.
All right, so Ms. Smith, are you in receipt of the letter to your client from Ms. Douglas?
Yes, Your Honor, if we are referring to the November 16th letter, it is Exhibit 5 of my pleadings. It shows the letter, a picture of the letter and a picture of the envelope that it came in. I am not in receipt of anything else from Ms. Douglas. Request to enter the premises, anything that she's referred to today to the court. This is all that I have, and I got it from my client.
Okay, is your client denying her entry to the property?
Your Honor, can you swear my client in so she can testify?
Sure. Can you please state your name for the record, Ms. Badon?
My name is Robin Badon.
Thank you, Ms. Badon. Do you swear to tell the truth and nothing but the truth?
The whole truth and nothing but the truth.
All right, thank you. Counsel, you can proceed.
Your Honor, our position is that any proper notice given, the property would be ready for inspection. Ms. Badan wants her property to be in good condition. And at one point when it was at issue, she wanted the heat to be turned on. So lack of access is something that we would like to categorically deny because Ms. Badan wants to live in a habitable property.
But did Ms. Badan 3 weeks ago deny entry to the property?
Ms. Badan, can you tell the judge what happened 3 weeks ago, as we have not discussed this specific incident?
I have no idea about what happened 3 weeks ago. Nobody came over here to try to get in. Nobody called to see if I was here, and nobody rang the doorbell. So I have no idea what has happened 3 weeks ago. What she's
All right.
talking about at all.
All right, okay, so what is your plan, Ms. Badan? What do you want to do?
Well, I want to move.
You can speak on her behalf, but is the plan to move, to vacate?
Yes, sir.
Okay,
And I would like some of my money back. I don't think I should have had to pay rent. The house isn't registered.
What Ms. Badan would like to say is that we would like this case dismissed, and she's requesting damages and attorney's fees in this matter for this action being filed. Yes, she does want to move, but she, first and foremost, this case must be dismissed.
what would the damages be?
Oh, the damages would be for when the heat was out and during the October through November months, which is what prompted her to have to call the city.
But how is she damaged? She had, was she paying? No, I'm sorry. What's Ms. Badan's rental amount?
Ms. Badan, what is your monthly rental obligation?
$625.
And when's the last time you paid that?
August.
August. So July, September, October, November, December, January, February, and March.
Well, Your Honor, this is a termination of tenancy action that was filed in December. So therefore, any acceptance of rental money would not be proper after December.
Yeah, but you want damages. So they're requesting damages. So I'm trying to figure out how she's damaged from not having to pay 5 months of rent at $625 and then not having a rental obligation for another 3 months, but yet still having some shelter that she doesn't own that she's occupying.
Yes, Your Honor. So the first and foremost, we are requesting a dismissal from the court. But as far as damages, the lockout claim, constructive eviction, MCL 600.2918 does say that interruption of services, essential services, in this case heat, is $200 per day, and that is the statutory damage on that.
So I'm supposed, but I'm not awarding damages. This matter is dismissed. Ms. Douglas, you have to refile this matter in court. Is
this dismissed with or without prejudice?
Without prejudice.
Okay.
This matter is dismissed without prejudice. I'm not awarding any damages. Ms. Smith, I appreciate your filing and your legal advocacy. But I will not be awarding lockout damages in this matter at $200 a day because there were repairs that needed to be made on this property that weren't made. However, I don't see how they can be made when was there a move out order for this property?
No, there was essentially a notice to quit, which I think the letter to the defendant would act as the notice to quit. So that was given November 16th. But there's no move out. We just wanted this case dismissed, and whatever equitable remedies the court would provide, we would be happy to accept. But the first
Okay.
priority again was the dismissal.
Yeah, this is a dismissal without prejudice. Plaintiff has the right to refile and file this hearing. Hold on, strike that. I have a question before I'm striking that ruling. Because it was my understanding that this case was filed as a non-payment of rent. But the complaint is actually a recovery to possession, a complaint to recover possession of the property. So it was noted in the answer that plaintiff requested rent and subsequently converted this case to a termination. Is that correct?
No, this was filed as a termination of tenancy from the jump. So that's why I was bringing up essentially the Park Forest argument about the rent from the date of the action being filed and the notice to quit. I think I received a copy of this file from the court when I went, but I don't have the pleadings in front of me, so I'm going to look at the ROA. Yep, termination of tenancy action. And that was the basis for the retaliatory eviction affirmative defense.
Yeah, when I filed, that was the choice given. The request for termination was because of lack of payment of rent.
Right. Right, and that necessarily wouldn't be a cause for a retaliatory eviction.
Well, first and foremost, the plaintiff's pleadings are bare, and the court rules require that she needs to plead just cause. However, with the retaliatory eviction, the facts that I laid out for the court, retaliatory eviction, MCL 600-5720, that is the 90-day presumption. Because the defendant called the city and then the action was filed subsequently, well within the 90 days, this statute compels the court to dismiss that action based on retaliatory eviction. There will be no judgment for possession, the statute says, when the termination was intended primarily as a penalty for the defendant's attempt to secure or enforce rights under the lease agreement or under the laws of the state, of a governmental subdivision of the state or of the United States. In other words, calling the city for an inspection.
What was that was my next question. So,
Your Honor, the letter states.
When was the city, go ahead, man.
The letter the lawyer is trying to say is retaliatory, does not say you have to move out because of call of the city. It says the city has ruled house non-compliant, and it also says, and you are $1,700 behind. That's the letter that she received from me. And that's a copy that the lawyer has, and then I put a copy in the packet to you.
So this case was filed in December. When was the city inspection issued?
So the defendant got a B-seed inspection done November 3rd, 2022. That is what Ms. Douglas is referring to as the date. That is Exhibit 1 in defendant's answer and affirmative defenses. Then on November 14th, there was blight violations. On November 16th, that is when plaintiff sent the letter to the defendant stating that she needed to vacate the property as a result of the inspection. The action was filed on December 16th. So this all happened roughly like a month and a half. And the statutory presumption is 90 days. So we're going from November 3rd when the city inspection was done.
Okay, court's going to dismiss this matter and deny all defendants equitable claims and also deny any violations of the Michigan Consumer Act, retaliatory eviction, any violations of the Housing Act, or breaches of habitability and reasonable repair. This will be dismissed without prejudice. So plaintiff can refile. Ms. Douglas, I suggest you get an attorney. You refile this matter. That concludes this matter. Good luck. Hope you all have a great weekend. Ms. Douglas, you don't have counsel. I can't provide you legal advice, but I suggest you obtain an attorney before refiling this matter. But you have every right to refile.
So you're on
Thank you.
dismissed without prejudice, correct?
Without prejudice, that is correct.
Thank you. Thank you. Okay, Ms. Badon, I'm gonna give you a call, okay? Thank you,
Your Honor,
Judge. Have a great weekend.
Your Honor,
You
this
too.
is James. Your Honor, this is James West. The call dropped while you were speaking on my case. I didn't hear the last part of your ruling.
There's a judgment entered for a move-out date, I believe, of May 1st, 2023.
May 1st, 2024, Judge?
No, 2023.
Oh, I'm sorry.
That was a.
Was it May 1st or May 24th? I didn't hear you, Your Honor.
It was May 1st. It was May 1st, Mr. West.
Okay. All right, thank you.
Have a great weekend. Thank you, everyone. Have a great
Have a good weekend.
You too, Your Honor.
Thank you,
All right.
Judge.
All right.
Happy Leprechaun Day.
Thank you.
Have a good weekend, Judge. Thanks.
Yeah. Oh, thank you. Have a great weekend.
Thanks. Bye-bye.
Bye-bye.